Addressing India's water dispute problem, the proposed Permanent Water Tribunal is a promising step, but it will face many hurdles. Do you think a Permanent Water Tribunal will be effective? As of now, how the interstate river water disputes are being redressed. Explain the major problems associated with the existing ad hoc tribunals. What is the way forward? GS Paper 2, Separation of Powers between Various Organs, Dispute Redressal Mechanisms and Institutions. What is the context about? The centre's proposal to set up a single, permanent tribunal to adjudicate on interstate river water disputes could be a major step towards streamlining the dispute redressal mechanism. The permanent tribunal will subsume all existing ad hoc tribunals. But it alone will not be able to address the different kinds of problems, legal, administrative, constitutional and political, that plague the overall framework. The Permanent Tribunal is expected to provide for speedier adjudication. But whether this will resolve the problem of protracted proceedings is doubtful. Do you think a Permanent Water Tribunal will be effective? Given the number of ongoing interstate disputes and those likely to arise in future, it may be difficult for a single institution with a former Supreme Court judge as its chairperson to give its ruling within 3 years. Tribunal's interlocutory orders as well as final award are likely to be challenged in the Supreme Court. In a landmark verdict, the Supreme Court said it had supreme power to hear an appeal arising from a river water dispute tribunal, under Article 136 of the Constitution. The idea of a dispute resolution committee, an expert body that will seek to resolve interstate differences before a tribunal is approached, will prove to be another disincentive for needless litigation. Thus, finality and enforcement of a tribunal sewer may remain difficult to find. As of now, how the interstate river water disputes are being redressed. At present, a new tribunal is formed every time a state government approaches the union government with a request. 8 such tribunals exist. After they have heard the matter and awarded their decisions, the tribunals are allowed to collapse. In general, it has struggled to bring warring parties on the same page and offer equitable solutions. Note, ad hoc tribunal has its roots in the Government of India Act, 1935, which mandated separate tribunals and limited the jurisdiction of the federal court. Parliament went ahead with the ad hoc tribunal arrangement, arguing that this would allow for quick decision-making and prevent protracted conflict between states. Explain the major problems associated with the existing ad hoc tribunals. There are 3 main problems. 1. Protracted proceedings and extreme delays in dispute resolution. The delays happen for a variety of reasons at every stage of the process. Sometimes, the centre takes years to decide whether a matter needs to be heard by a tribunal in the first place. For example, the Godavari and Krishna dispute started around 1956, but the matter was referred to a tribunal only in 1969. After the tribunal has been formed, it again takes many years to pronounce its award. 2. Opacity in the institutional framework and guidelines that define these proceedings. There are too many options, and there is too much discretion at too many stages of the process. This is partly because of procedural complexities involving multiple stakeholders across governments and agencies. This nature of the system is equally the result of factors outside the efficient functioning of the tribunal itself. 3. Non-compliance. Problem of non-compliance comes when state governments reject the tribunal awards. For example, the Punjab government played truant in the case of the Ravi Bees Tribunal. Water is a state subject, but the regulation and development of interstate rivers and river valleys in the public interest is on the Union list. However, the center has generally taken a back seat, allowing states to dominate the way forward. Today, interstate water disputes are no longer just about water allocation. They have become hugely politicized. The recent eruption of the Kauveri dispute, framed as an ethnic identity issue between Tamilians and Kannadigas, which led to widespread civil unrest, is only the most recent example. Public opinion is an important factor that cannot be wished away. The central government must keep these factors in mind when setting up the proposed tribunal. A robust institutional framework, and a transparent one to ease state and public buy-in, is a must. Without that cooperative approach, India's water dispute resolution is unlikely to see much improvement.